today for the fourth and final argument of today's docket. We have one more case tomorrow for the November session of the Tennessee Supreme Court. As we stated earlier, we are hearing these cases by Zoom video conferencing here today, as we have done for the past several months, as our way of moving our cases forward while the pandemic is ongoing, so that we can balance the health and safety of everyone involved in the situations, while also continuing to push the dockets along so that we can cover what we need to do. While it's not quite the same as being in person, we have found it as an efficient and useful way of moving those cases forward. And so we're happy to be here with counsel, as well as any of you who are watching us on the live stream on our YouTube channel. We're glad that you have joined us as well, and hope that this will be an opportunity for you to learn more about our judicial system, and specifically more about how your Tennessee Supreme Court operates. So in just a moment, we'll begin the arguments in this case. Each side will have 30 minutes for argument. If the appellant wishes to reserve time for rebuttal, please do so before you begin your argument. And I understand that the Appellee's attorneys are going to split time. So when it's time for you to do so, if you will identify who is going for how long, that would be helpful as well. All right, at this time, Mr. Hibner, I think we're ready to proceed. If you'll call the first case, please.
Elvis Presley Enterprises, Inc. et al. Versus City of Memphis et al.
All right, Mr. Wilbon.
Thank you, Your Honor. May it please the court, Clarence Wilbon for the appellant, and I'd like to reserve 15 minutes of rebuttal time, Your Honor.
All right.
We're here today because, in the words of Judge Stafford, the majority opinion from the Court of Appeals defies logic and reason. At best, the Court of Appeals confused well-settled Tennessee jurisprudence, and at worst, the opinion established new law that warrants reversal by this court. Contrary to the majority opinion, it is well settled in Tennessee that a dismissal of a case based on failure to exhaust administrative remedies does not constitute an adjudication on the merits for purposes of the res judicata doctrine. In arriving at this incorrect decision with respect to this case, the majority completely ignored and disregarded the actual facts and occurrences in this case at the trial court level. The trial court, by way of an order, actually ruled clearly and concisely that the court was not adjudicating the merits of the case. The trial record is clear that the order itself says that it is not a adjudication or on the merits of the lease which underlies this litigation. As well as in the transcript, which is a part of the record, the court made clear in stating that Elvis Presley Enterprises failed to exhaust its administrative remedies, and specifically, it had to go back to the Industrial Development Board, the local Industrial Development Board, which is known as EDGE, and obtain a vote before the court could actually entertain the jurisdiction. And by way of background, Elvis Presley Enterprises operates the Graceland tourism business located in Memphis, Whitehaven, Tennessee. After completing an unprecedented revitalization and addition project in 2016, which included the addition of a world-class 4-diamond hotel, a soundstage, and other state-of-the-art tourism facilities. In 2017, Elvis Presley Enterprises embarked on a journey to further enhance the Graceland campus by adding additional sound stages, an airplane hangar, and more importantly, for purposes of being here today, a 6,200 seat arena. Importantly, in connection with all of the Graceland project improvements, including the hotel and the sound stage, Elvis Presley Enterprises received tax incentive financing. Specifically, it received a TIF. It received what we refer to as the Graceland TDZ and the Graceland surcharge, which was established by way of statute. Those tax financing vehicles allowed Elvis Presley Enterprises to receive up to 50% of the additional taxes above the original base on the Graceland campus when the improvements are in place. In spring of 2017, as I just noted, EPE decided that it wanted to add the 6,200 seat arena. As expected, it went back to the Industrial Development Board, as well as to the City of Memphis and Shelby County to discuss this addition. The city, the county, and EDGE, along with EPE, were all ecstatic about the future development that EPE wanted to establish, including the 6,200 seat arena. Now, after much discussion with these entities, the Memphis, what I refer to as Memphis Grizzlies, but it's known as Hoops, originally was known as Hoops, and now is Memphis Basketball for purposes of this case. Again, I'll refer to them as the Memphis Grizzlies. The Memphis Grizzlies objected to the 6,200 seat arena being constructed on the Graceland campus on the basis that as a recipient of tax increment financing, it could not go forward because the arena use agreement that was entered into by and between the Memphis Grizzlies, the City of Memphis, and Shelby County in connection with the FedEx Forum, where the Memphis Grizzlies play basketball, it said that the city and the county would not compete with the Memphis Grizzlies. So again, Memphis Grizzlies objected to the 6,200 seat arena and the tax increment financing going from 50% to 65%. The parties attempted to resolve their differences to no avail. So in November of 2017, Elvis Presley Enterprises filed a lawsuit in the Chancery Court of Shelby County, Tennessee, seeking a declaration that the arena use agreement did not prohibit Elvis Presley Enterprises from using the funds flowing from the TIF, the TDZ, and the surcharge to pay for a portion of the construction related to the 6,200 seat arena. Chancellor, each of the appellees moved to dismiss that lawsuit on the basis that EPE lacked standing to bring the lawsuit because it was not a named party to the actual arena use agreement. Chancellor Cowell ultimately heard argument on those motions, and during the course of those arguments, the discussion migrated to discussion regarding or to pivoted on the EPE's failure to exhaust its administrative remedies, but more specifically that EPE had failed to obtain a favorable or disfavorable vote from the Industrial Development Board known as EDGE. So Chancellor Cowell again specifically stated that as a result of EPE's failure to exhaust its administrative remedies, it lacked standing and dismissed the case. Consistent with Chancellor Cowell.
Mr. Willman, this is Justice Clark, and let me interrupt you right there because that sentence in a single sentence may be causing inconsistency. And does that complicate your case in any way? It does say, since it hasn't exhausted administrative remedies, but it goes on to say EPE lacks standing. One of those may be a final type of adjudication, the other may not be. How do we look at this and interpret it when they're both in the same sentence?
Well, I think, Your Honor, when we look at that sentence, we have to look at the word before that comes before EPE has not exhausted its administrative. It says, since EPE has not exhausted its administrative remedy, EPE lacks standing to bring this matter before the court. So when you look at the whole sentence in context, it says, since EPE has exhausted its administrative remedies, which entails and paints a clear picture that that's the same as a result of EPE failing to exhaust its administrative remedy. The sense guides us and helps us understand what the trial court meant. And then if you take that in connection, Your Honor, with the actual order that was entered, the court went further to say, to make clear that it was in no way was that order or that ruling intended to address the actual merits of the case. So the basis for the lack of standing was EPE had not exhausted its administrative remedy. So I think they actually dovetail or fit, kind of hand in glove, Your Honor.
Thank you.
And so that brings me to the point to where I was going, Your Honor. We EPE, and when that case was dismissed, consistent and pursuant to the Chancellor Cow's orders, EPE specifically went back to the Edge Board and obtained a vote. Not only did it obtain a vote, it obtained a favorable vote. And the next step there was to go to Shelby County and obtain a vote for them. And once again, EPE received a favorable vote from Shelby County. The city of Memphis, in particular, the city council, deferred on issuing a vote up or down, saying that in its mind or in its view, EPE needed to get the ruling from the court and they would then come back. So there we have the three bodies that would make a decision relating to yay or nay on the additional 15% or whether you could use it to build the arena. Two chimed in and said specifically that we approve this subject to the Chancery Court approving it or a settlement with appellees. Well, no settlement was reached with the appellees. So EPE went back to the Chancery Court by way of a new lawsuit and filed a second declaratory judgment action based on the developments that were brand new, which didn't exist prior to the EPE going back and obtaining the two resolutions. So at that time, armed with some instruction from the county and the Edge Board that said you are, as long as you go and get the Chancery Court to give you two thumbs up, so to speak. He went back to seek those two thumbs up from the Chancery Court. And at that point, the Chancery Court again dismissed for lack of standing and specifically stated that essentially, and if you look at the transcript, which is a part of the record, it said, I'm not going to address my basis for why I'm saying you lack standing, but you just lack standing. So at that point, EPE appealed to the Court of Appeals, and much to the dismay of EPE, the majority opinion in the Court of Appeals came back and said that the first ruling operated as an adjudication on the merits, and as a result, the res judicata doctrine operates to bar EPE from maintaining a second lawsuit.
Mr. Wilbin,
this
let me ask you a question. Sorry, Justice Page, I didn't see you jumping in.
That's all right.
Is there any evidence, actual evidence in the record that the failure to obtain this TIF funding and the additional 15% would have made this proposal economically infeasible for EPE to proceed, were they not to get that?
Well, Your Honor, I think what the record reflects is that the additional 15% was indeed necessary for EPE to move forward with the project. So it was definitely relying on that project, on those funds to move forward with the project. And as a result of not getting those funds, EPE suffered a unique injury that no other taxpayer suffered as a result. So again, the answer is yes, Your Honor.
Mr. Wilbin, this is Justice Page. My question is almost related to Justice Bivens. If we agree with you on your argument with respect to res judicata, is the record developed enough that we can decide the standing issue, or should it be remanded to the trial court? What's the status of that record there?
I think, Your Honor, the record is very clear that we were at that EPE would in fact have standing, because the record has the transcripts in it from the the Edge Board meetings, the Shelby County Shelby County Commission meeting, as well as from the City Council meeting. And what those meetings, what that establishes is that those resolutions and those transcripts make very clear that EPE has been, has received the necessary approval from those bodies. So all we need now is to get the approval from the Chancery Court. And if you obtain that approval from the Chancery Court, you're able to move forward with the project. And that's all it would take to need standing. If you look at the Calfee case, I think, if you combine the record with the Calfee case, which we believe to be the law of the case here, as a 2017 case. So when we filed our suit in November of 2017, that was an extremely recent case. It was, I think, only 3 to 4 months old. but based on the record where it's clear that the Shelby County Commission, as well as the City Council, as well as the Edge Board, the only three entities that would actually have any say in whether or not the funds could be used, the additional 15% could be used by EPE. They've made clear that they were in favor of that, and that if you get this ruling from the Chancery Court, you are ready to go forward. So as a result of that, we think the record is clear. And furthermore, Your Honor, so that we're clear here, EPE was not looking to say that they were a party or enforce the arena use agreement. So from a standing perspective, what EPE was seeking was, what are my rights, or how is this arena use agreement is infringing upon my rights and privileges as it relates to a party that already has a Graceland TIF, a Graceland TDZ, and a Graceland surcharge. And I stress the word Graceland because there's no other taxpayer that has or is a beneficiary or receives benefits from the TDZ, the TIF, or the surcharge, Your Honor.
Well, Mr. Wilson, this is Justice Bivens again. And so is it your position that the fact that you had previously received that assistance for the initial round of projects a critical factor in you having standing in this case to go forward?
That is correct, Your Honor. The fact that we are talking about a TIF, a TDZ, and a surcharge that was exclusively Graceland's. So Graceland was already proceeding under that TIF, TDZ, and surcharge. So they were operating, they're doing business on here, and they looked to expand what they could do with their own TDZ, TIF, and surcharges. So much so, Your Honor, that the surcharge is a creature of statute that was passed for the Graceland campus. You know, so it would give EPE standing because that is EPE is, that's their right, their privilege, their surcharge, TDZ and TIF, Your Honor.
Thank you, Mr. Wilden.
Thank you, Your Honor.
All right, counsel for the defendants, somebody who wants to, who's leading off here? Mr. Wade, you're muted. You're still muted, Mr. Wade.
Some people like me better that way, Your Honor. David Wade, I'll be speaking on behalf of Memphis basketball. I'm allotted 13 minutes. I'll be addressing the res judicata issue. Mr. Lakey, representing the city, has 12 minutes. He will be addressing the standing issue. Mr. Jones, we've agreed, would have 5 minutes. He will be addressing the issue as to whether or not the county appointed Elvis Presley Enterprises as its agent to sue the county.
All right.
They will be allocated. Your Honor, I'm David Wade. I represent Memphis basketball. I'm assisted here in the room by Rebecca Hines. I'd like to point out that all parties to the contract agreed that there's to be no public funding to build a competing facility with the FedEx Forum in Memphis. In its brief at page 5, Elvis Presley says that Memphis basketball, and I quote, prohibited EPE from constructing the arena. That's their arena at Graceland. Memphis basketball did nothing of the kind. As the majority opinion points out, Memphis basketball stood on contract rights, but EPE can build its arena today. It just can't use public funds to do it. It's interesting in analyzing the Court of Appeals ruling to take a look at the majority opinion counterpointed with the dissent.
Well, Mr. Wade, this is Justice Bivens. Let me interrupt you there and kind of let me ask you in essentially the same question I asked Mr. Wilbon. And that is there evidence in the record that EPE could not, it would not be economically feasible for them to go forward with this arena absent the TIF and other funding?
I know of no evidence in the record that addresses that issue at all, Your Honor. If I may, look, this case from the res judicata standpoint is about finality. Regions versus financial case we've cited says the public policy underlying the doctrine of res judicata is to promote finality in litigation in order to conserve judicial resources to relieve litigants from the costs and vexation of multiple lawsuits. For nearly 20 years, the Grizzlies, as I'll call them, and the city and the county have honored this contract, and they've done it in a way under the financial structure put in place by the parties, as the Court of Appeals majority opinion recognized. In 3 years since EPE's tried this, they filed 4 lawsuits, all of which have now been dismissed. And the latest was just last week by Judge Mays in federal court, charging the city with conspiracy. What we're dealing with is a contract. As the majority opinions noted in its recitation of the contract, this agreement arose 20 years ago when the city of Memphis, a basketball city, desperately needed a major league team here in Memphis. They reached out to the Vancouver Grizzlies and they reached an agreement.
Mr. Wade, this is Justice Bivens. Let me interrupt you. With regard to the majority COA opinion, I mean, it's in essence has gone off on the res judicata grounds and is not making any particular findings, as I understand it, with regard to the merits of the lawsuit.
No, sir, it is not.
Res judicata. So address it, if you will, please, from the standpoint of support for their decision to invoke res judicata in this situation. As I understand it, is this argument you all didn't even make strongly, at least strongly at the time.
Well, actually, we did make the argument. It was my lead argument in the Court of Appeals. I did address it in the Court of Appeals in response to Judge Armstrong's questions.
In response to his questions, yes.
The issue that we have here is whether or not Elvis Presley Enterprises, at the time that it could have, had all the bucket of information it's now claiming that it didn't have when it filed EPE2. It had
Mr. Wade, this is Justice Clark. Isn't the real issue that we have before us whether a judge's dismissal of a case based on failure to exhaust administrative remedies is a final judgment or not? We're not really looking at any of the merits of this case. You all were there to argue perhaps the merits, but the judge said you're in the wrong, said to Mr. Wilbin, you're in the wrong place because you haven't exhausted administrative remedies. What's the Tennessee law on whether that's a final judgment or not?
Tennessee law on whether that's a final judgment, Your Honor, is 4102. 4102, Tennessee Rules of Civil Procedure 4102 says, and unless the court in its order for dismissal otherwise specifies, other than for lack of jurisdiction or for improper venue or lack of indispensable party, the judgment operates as an adjudication on the merits.
Yes, sir, but we've had a lot of cases in Tennessee where the judge didn't say one way or the other, and appellate courts are often called upon to determine whether on those facts. And so isn't there some case law that talks about whether failure to exhaust administrative remedies constitutes a final judgment on the merits? I want you to talk about that authority.
I'd be glad to. Let's focus on the Pendleton case. It was a lengthy opinion written by Judge Koch, as is his style. It involved a situation in Pendleton where an inmate had filed its case before it exhausted administrative remedies. In the process of the pendency of the case, the defendant did exhaust his administrative remedies, but the trial court didn't consider that. The case went up to Judge Koch. The Court of Appeals reversed and remanded and said that because the plaintiff had exhausted administrative remedies during the time of the case was pending, the trial court should have considered that. And that's our point. Here, the administrative remedies issue was raised by EPE, but they resolved that issue while the case was pending, and they chose not to bring it back before Chancellor Kyle. The argument is well, as the dissent pointed out, the dissent tried to argue that there was a Kafka-esque problem with trying to get all this stuff together. But EPE did it while EPE1 was pending. It had a bucket of information. The ruling in by the majority, or the determination by the majority, was fairly straightforward. The dissent says, well, they said they put EPE in a catch-22, that if it took it back to Chancellor Kyle in a second lawsuit, they were precluded. Well, that's not what the majority opinion said. The majority opinion said is that EPE had all the information it needed and simply did not take it back to Chancellor Kyle. There was a huge discussion in the briefing about Rule 5904. EPE says that it could only file its motion to alter or amend within 30 days. Now, the city filed its motion to alter or amend within 30 days. There's plenty of cases, and just as Your Honor said, there's been plenty of case law that deals with 5904 and 5905, that when once a motion is filed, then the judgment in the court is not final. It's open for all issues. The trial judge can consider all issues, even after the 30 days has expired. And it is the Byrne case that we cited says that failure to exhaust administrative remedies calls for a Rule 10b6 dismissal. If Elvis Presley Enterprises had done what it was supposed to do, it had taken the information that it had and it brought it back to Chancellor Kyle, we would not have been involved in 2 lawsuits and 2 years later with a whole different appeal. There's been no excuse given why it could not have done that. The interesting thing is that the majority opinion points out the events that took place as alleged in the second complaint. They all occurred while the case was pending in front of Chancellor Kyle and EPE 1.
Let me clarify something, Mr. Wade. This is Justice Kirby. Okay, so am I correct then in saying that you are not arguing that failure to exhaust administrative remedies is a judgment on the merits? You are not arguing that. You are more arguing this supplementation of the record issue. Am I correct in that?
Well, with all due respect, Your Honor, I've got to say that 4102 says what it says, and it deals with the question of whether it's a judgment on the merits. And under the strict language of 4102, it was a judgment on the merits based on the language of the rule. We're also saying that during the pendency of EPE 1, all the facts were known. And yes, ma'am, we're saying that as well. Because the facts were known, the duty was on EPE 1 to bring it back to the court.
Mr. Wade, what do you mean exactly when you say facts were known? As I understand this, EPE was told you need to go to these different administrative agencies and get a ruling. A ruling is different from knowing facts. So what is it that they knew that was legally sufficient to comply with the judge's original determination that they had not exhausted administrative remedies?
Thank you, Justice Clark. The fact is EPE 1 had gone to the county, or Elvis Presley had gone to the county, and they got this conditional approval they talk about. They had gone to the Edge Board, same kind of approval. They'd been to the city council, and the city council had refused to act. And then when they filed their lawsuit, Elvis Presley Enterprises 2, they alleged that they had done everything they were supposed to do to give them standing. The fact is that under the chronology, they had done all of those things while Elvis Presley Enterprises 1 was still pending. So
pending where? In the trial court or in the appellate court?
In the trial court. I mean, that's one other thing. No appeal was ever taken from Elvis Presley Enterprises 1. It became final. If an appeal had been taken, and if they had these after discovered facts under Trap 14, they could have brought that to the attention of the appellate court. So they had that remedy. They had the remedy of a Rule 60.02 that the majority opinion pointed out. The fact is the prejudice to my client being involved now in a second lawsuit is that all of this should have been taking place in the first lawsuit. And that's the sound jurisprudence in the state of Tennessee. That's why finality is important. That's why.
But how are you really damaged by this? You had the trial court opinion that says, I'm going to dismiss you for failure to exhaust administrative remedies. Yeah. EPE says, okay, we failed to exhaust administrative remedies. They exhaust their administrative remedies in their view, and then they file a second lawsuit that says, okay, we have now exhausted ours. I mean, I'm having a hard time seeing how the need for the Rule 5904 supplementation, and I mean, how are you damaged? How are you injured by this?
I mean, with all due respect, Your Honor, it's not a matter of damage. It's a matter of prejudice. The law established the prejudice that we don't have to put up with a second lawsuit. The law establishes that the first lawsuit, if it is to be properly adjudicated, needs to all be accomplished in one case.
But Mr. Wade, what difference does it make on these facts? The merits of the case were not addressed in the first case. Now Elvis Presley Enterprises has done what the judge has required, and they come back and they're starting over, and now you will deal with the merits since they presumably will be told they have standing if in fact they've done what they were supposed to. What practical difference does it make if it's under a case number 2034 or a case number 2075?
We expended a huge amount of effort in trying to deal with Elvis Presley Enterprises 1. The city filed its motion to alter or amend. And during that time, Elvis Presley Enterprises went to all kinds of activities. And the fact of the matter is, in my humble view, is that the prejudice to us is that we had, first of all, Elvis Presley Enterprises could have and should have appealed that first ruling, and we would have had an appellate right there. Under the theory that Elvis Presley Enterprises is fostering now, we don't have that.
Mr. White,
why should they have appealed it though? They were willing to, the judge said, you don't have standing here until you do these things, and they were willing to go do them. What did they need to appeal?
Well, with all due respect, Your Honor, the standing issue, and Mr. Cook can handle that, it was not based on whether Elvis Presley Enterprises went to all these venues. That was not the standing issue. The standing issue is that Elvis Presley Enterprises came along 20 years after our contract and is trying to insert itself to have a right to have the contract interpreted by them when they're not a party or a third party beneficiary and have no connection with the contract. So
that's the merits issue.
Well, that's right. But the fact that they did the things that you're talking about was not the standing issue, Your Honor.
Well, Mr. White, I understand you're just answering questions, but your time is well past expired. So let's move on.
Yes, sir.
Good afternoon. Can you hear me?
Yes.
Good afternoon. My name is John Lakey. I represent the city of Memphis, and I'm really going to focus on the standing issue. But in doing so, I would like to, before I dive into that, if I could just touch upon a couple of questions from Justice Kirby and Justice Clark. Justice Clark, I believe that every administrative step that EPE alleges that it has taken in the current lawsuit, when they came back in for EP2 and said, now Chancellor Kyle, we've done X, Y, and Z, and we're back. Everything that they alleged that they did occurred before the first lawsuit was final, before the first lawsuit was a final judgment. And and it's not my issue, and I'll let Mr. Wade has covered it, but I think under Jackson v. Smith, this court's opinion of 2012, the four factors that have to be required to be shown and for res judicata to apply don't include that the defendants have to show that, or one of the parties have to show they were prejudiced. That's not one of the four required factors. But with regard to standing, and that's the grounds on which Judge Kyle, after knowing the administrative steps had been taken, came back the second time and said, well, you took the administrative steps now, but what I'm going to find is you just don't have standing to seek a declaratory judgment seeking an interpretation of the arena use agreement. That's the issue that I'm going to focus on. And before diving into that, to answer questions that had been raised by Justice Bivens and Justice Page, yes, Justice Bivens, we agree. This will be the only time you'll hear me say this. We agree with Mr. Wilbin. We think the record is complete, that the court can make a decision on the standing issue. You have all of the information that was before Chancellor Kyle when he made that decision. And even though the Court of Appeals did not reach that because of the res judicata grounds, we think in all judicial economy, it would make sense for this court to address the standing issue if it does not affirm the Court of Appeals on the issue of res judicata. And they're two separate issues. I do respectfully disagree with Mr. Wilbin. If this court decided today, if this case was simple, if you disagree with us on standing, and this case goes back to Chancellor Kyle and he rules that the way they want on the contract, EPE can't proceed with the construction of an arena and receive public funds. They don't have the ability to do that, because while Mr. Wilbin might want to say what the city council said when they took the issue of the increased TIF funding back to the city council, the fact is, and as alleged in the complaint, the city council did not resolve either way. It did not vote to agree that EPE could use TIF funding for the arena project. And the city council under the statute has to approve that before that funding can be used by EPE.
But Mr. Lakey, this is Justice Kirby, you are taking away their opportunity to seek that. So that's what we're talking about, right?
That's right. And I'm not taking their opportunity away. The Constitution does, because they don't have standing to seek. They don't have standing. They don't have a justiciable interest to seek a interpretation of a contract to which they're neither a party nor a third party beneficiary.
But Mr. Lakey, this is Justice Clark, and that's the merits issue. Are you saying that if they had taken these various steps and come back to Chancellor Kyle while the first case was still pending and said, okay, we're back, and now we need you to review and see if we've done, and then you all would once again raise your issue and say, well, forget whether you've exhausted administrative remedies because you don't have standing anyway, that would have been okay, but that their choice to turn it into a second lawsuit is not okay? Because that's all we're looking at.
Well, Your Honor, I know we have a little bit of an issue with that regard, because the actual request for appeal was limited to res judicata. But again, EPE did raise in their briefs, as did the appellees, the issue of standing. And Justice Clark, that's the exact situation we're in this case. In EPE2, the current case that Chancellor Kyle issued an order on, he knew and had in the complaint every administrative step that had been taken by EPE, the ones that he'd said before, go forth and do these things. EPE did that. And when the second lawsuit was filed, Chancellor Kyle looked at that and said, okay, you did that, but I'm going to find now that you do not have standing to bring this lawsuit. That was the ruling. Now,
perhaps our confusion is because he used the term standing in that sentence where he said, I'm dismissing it because of failure to exhaust administrative remedies. I understand that for you, the merit standing question is what you have tried to raise. Are they parties to the contract, and did they have a justiciable interest in all of that? I'm not trying to take away from that, but we still are a step back in what we've asked you to look at in terms of the res judicata issue.
Right, and with all due respect, Justice Clark, that was Chancellor Kyle's language in his first order of dismissal. The case, which relates to this case because of res judicata. In the second order of dismissal, Chancellor Kyle dismisses the case on standing. He makes no reference to them. He makes no reference in the order of dismissal that has come up through the Court of Appeals and now is before the Supreme Court, that the dismissal was based on the fact they had not completed their administrative steps. That was the order in the first case, not the case that's pending before the court.
So this is Justice Kirby, Mr. Lakey, on the straight standing issue based on the contract, who are the parties to the arraignment, the FedEx Forum agreement?
I'm going to go through that because this is what I'm really want to try to address, because this is the argument I presented to Judge Kyle that he granted in the second lawsuit, the case we're in front of you. The arena use agreement is a contract between the city, the county, and Memphis Basketball. They're the only three parties to that contract. And as Mr. Wade said, that secured the move.
So could the city then seek a declaratory judgment interpreting that agreement to determine whether it barred the arrangement, the approval for the Elvis Presley arena? Could the city seek that declaratory judgment?
I think any of the parties to the contract could seek a declaration as to a provision that's currently at issue. And so, okay, yes, I think the answer to that is yes.
Could Edge seek a declaratory judgment determining whether it could grant the tax incentive or recommend the tax incentive, or
no,
whether
I don't.
Presley's agreement is an impediment to that?
Excuse me, Justice Kirby, I'm sorry for interrupting you.
No,
I don't believe Edge has standing to bring the lawsuit to seek a declaration with regard to the arena use agreement.
So both the city, you're saying that only, even if you're not seeking enforcement, and nobody's seeking enforcement, quite the opposite. EPE is not alleging it is a beneficiary. It is alleging that the agreement operates to its detriment.
Right.
Sort of the converse of that. So you're saying that if EPE were seeking to benefit from the agreement, they could get a declaratory judgment, but because in this situation, they are saying that operation of the agreement operates to their detriment to prevent them from having the opportunity for the tax incentive, then they do not have standing. Do I have that correct?
You have it half correct from my perspective.
All right, go ahead.
I don't think if they said they wanted to get a benefit from the contract, they could bring a declaratory judgment action. I think under the clear jurisprudence in Tennessee and other jurisdictions, if you want to seek a declaration as to the interpretation of a provision of a contract, you have to be a party or a third party beneficiary. And that's the only argument that they really have under the law, the third party beneficiary argument. They make that as their alternative argument.
Mr. Lakey, this is Justice Clark, are you effectively saying that in this particular fact situation, the city and the county have entered into a contractual agreement with a separate single corporation, or they may be a group of LLCs, but whatever Memphis Basketball is, however they are created, that limits the right of every other single person or entity to ever come forward and seek to build an arena with more than 5,000 seats, and that they have no ability to seek to challenge that or seek relief from it?
Absolutely, I'm not. EP can go out tomorrow, yesterday, today, and build an arena with its own money.
But not with city money.
Well, yeah, right,
not,
Your Honor.
Not with public money.
Excuse me again for talking over you. It's harder with Zoom.
It is hard.
The question in standing is, do you have a legally protectable interest, right? That's the first component of standing. With all due respect to Elvis Presley, private entities don't have a legally protectable interest in receiving public funds to build private projects. They just don't.
Well,
excuse me.
Excuse me. Let me ask it to you this way. Let's assume for a second that we have a situation where EPE goes to the city to request additional TIF funding, approval of that. And the city actually denies that. And the city cites as the basis for that denial, that it's required to deny it because of the terms of the arena agreement. Would EPE then have standing to sue the city for an improper basis for denial of the TIF claim?
I don't believe they would, Your Honor. Again, I don't, what could conceivably happens in that scenario is that a decision to approve the TIF funding You know, the contract wouldn't prohibit it. What it would do is place the city potentially in breach of the arena use agreement and subject to the various remedies set forth in there. I don't believe that would any more give EPE standing to seek an interpretation of the contract than they have now. They and I know, I've heard this, and I haven't mentioned the word Calfee, which is, I know, with the case that Mr. Wilburn will rely on. And I will say to you, Calfee involved the granting of a permit, a challenge to an administrative action. I don't think it's applicable here. It didn't involve a contract. Here, the only way that EPE has into standing potentially would be as a third-party beneficiary. The courts are clear that when you're dealing with the government as an entity, in order to be a third-party beneficiary, and I see I'm running out of time. I don't know if you want me to finish my thought or stop.
Just real quickly finish it.
Well, so when you're trying to be a third-party beneficiary in a contract that deals with the government and another entity, there's even a heightened standard. That contract has to be very specific and manifest a specific intent to provide a benefit to you. EPE relies on the Smith case, it's cited in our brief, and I think it actually shows why they aren't. If you look on the provision they're relying on, Your Honor, it simply does not express any manifest intent to benefit the Grizzlies or anybody situated like them.
All right, thank you. All right,
thank you, Your Honors.
Jones.
Mr. Jones, you're muted.
Yeah, you're still.
It's easier to do this in person, having done it once before in my 32-year career. Your Honors, I'd like to address just very briefly the contingent resolution that was passed by the county commission.
Mr. Jones, I really can't hear you. Do you think you could move a little closer to your microphone?
Mr. Hebner indicated that was a problem. Is that better?
A little bit, yeah.
A little bit, yeah, not a lot. Still a little muffled sounding.
Yeah, we'll try hard to listen.
Okay, I thought I had during the break between entering the Zoom, I thought I had cleared that up on my own computer by increasing my mic volume, but apparently not. But Elvis Presley Enterprises claims that the county's contingent resolution confers standing on it to pursue the lawsuit. And for several reasons, that is, Elvis Presley is incorrect about that. Primarily, Your Honors, Shelby County could not make Elvis Presley Enterprises its agent, even if it wanted to, under the operating agreement, to do so without obtaining the consent of Memphis basketball. The county would be in breach of the agreement. It simply can't do that. The relevant portion of the operating agreement is quoted at page 36 of our brief. It's section 22C, and the relevant words provide, city/county shall not assign this operating agreement or sublease its rights herein or delegate any of its duties hereunder to any other person without the consent of Hoops. And as the court knows, Hoops is the predecessor to Memphis basketball. In addition, notwithstanding EP's arguments, the resolution does not instruct, authorize, or order EPE to do anything, much less to go to court and obtain a judicial declaration about what the operating agreement means. Elvis Presley contends further, relatedly, but further, that the clear intent and purpose of the contingent resolution was for EPE to go into court on behalf of both EPE and Shelby County to seek an interpretation. EP doesn't allege that in its complaint, and if it were truly suing on behalf of Shelby County, it's not. It would have to allege in its complaint that it were doing so. Rule of Civil Procedure 17.01 requires that every action shall be prosecuted in the name of the real party in interest. And when you boil it down, Your Honors, EPE's position just can't stand scrutiny. What EPE is telling you is that the Shelby County Commission instructed Shelby County to sue Shelby County in Chancery Court. And that's not what the resolution says, and certainly it's not what the resolution means. And unless the court has any questions, that's the conclusion of my presentation.
Okay. Thank you, Mr. Jones. All right, Mr. Wilburn, for your rebuttal.
Thank you, Your Honor. I'll start briefly by addressing the argument Mr. Jones just made. The record in this case reflects clearly that the transcript from the Shelby County Commission hearing, I keep wanting to call them hearing meetings, I'm sorry, Your Honor, the Shelby County Commission meeting, where the Shelby County Commissioners themselves state that we are issuing this resolution with, one, we're approving this request contingently, but two, they say that we've been needing an interpretation of this very agreement for many years. And this resolution, in fact, allows them to go obtain this particular interpretation. So I think the record is clear on that. So I won't spend much more time addressing that. But I would like to point to something in the actual arena use agreement as it relates to the standing discussions that have taken place today. So again, I like to use the phrase that we can't always look at everything in a vacuum. There's been a lot of discussion about, and Mr. Lakey elaborated on it quite a bit about, in essence, he's saying the city, the county, and the Memphis Grizzlies created a contract that says we can do anything we want to any citizen in Shelby County, Memphis, Tennessee. We can do it and use it against you any way that we want, and you never, ever will have a right to challenge what we do to you. Today, if we want to treat you good, we'll say it's under the basis of this agreement. Tomorrow, if we want to deny you of all of your rights, we're going to do that. And guess what? You never have a right to challenge that. And he was right. I am going to speak of Calfee. Calfee goes right against what he's saying and says that if you are in a unique position like EPE is and have a TIF, a TDZ, and a surcharge, that Memphis Grizzlies, the city of Memphis, nor Shelby County have a right to come in and pin you down with that and say you don't have a right to ever get up. And we can do what we want to you as it relates to your TIF, TDZ, and surcharge. That's just not correct. And I will point, if your honors will indulge me just a moment, to read a provision from the actual arena use agreement itself that further clarifies that the city, county, and Memphis basketball position in that regard is wrong. It further says that the agreement itself says, provided in the non-participation provision, it says, provided, however, the foregoing provisions shall not be interpreted to prohibit transactions and activities normally and or routinely engaged in by the city, county, industrial development corporations, and or the city and or other city, county affiliates, the general purpose of which is to encourage private development in the ordinary course of establishing tax freeze programs, tax incentive programs, pilot programs, and other similar economic programs aimed at encouraging private development. So what we have here with EPE fits squarely within that. You have a tax incentive program that was encouraged by the city and the county and the Industrial Development Board. In fact, they are EPE's public partner in this public-private partnership. So they have specifically said, they being the Memphis Grizzlies and the other entities, we are not going to use this to pin somebody like EPE down. They agreed to that on the front end. And now when EPE comes,
Mr. Wilburn, if I may interrupt that for a moment, I understand what you're saying, but if I'm correct, and you can help me with the details, In 2014, you submitted and got approval for a Graceland economic plan, and you were granted a TIF based on that plan, whatever it looked like at that time. That plan and the TIF did not relate to anything else new or different, and EPE apparently recognized that because you knew you had to go in and get approval to amend the scope of that plan. So I want to be sure I'm not hearing you say now that once you have a TIF, you can use it for whatever you want to, and you don't need other approvals. Help me with that a little bit.
No, Your Honor, I'm saying just the opposite. What I'm saying is EPE submitted a supplement and went to get those approvals. And the key here is those approvals have been contingently granted. So once EPE now has the TIF, the TDZ and the surcharge that no one else has, and it has the approvals to go along with that. And
but what's the nature of that approval? We keep talking about that, but aren't the approvals kind of versions of, it'll be okay with us if you do that as long as the court rules in your favor on the interpretation of the contract?
Well, that's correct, Your Honor. What they're saying is, so there are steps that you have to take. You're not able to just, put one foot in front of the other and get there without other involvement. So what they're saying is, you are approved. Go back to the court, get the court to say that it's okay for you to do it, and then you don't have to come back to us. And so that's why EPE is uniquely situated to where EPE is not intending to enforce this contract or to do that. EPE is not even challenging the enforceability of the contract. EPE is specifically saying that the contract is being used to pin EPE down. And all they're saying is that right? Can you strip EPE of its rights using this contract? And that's all it's asking the court. Is this permissible? Can they truly do this to me? Can I be stripped of a right to use these funds that I've been approved of? Because that's the only step that's left.
But you were approved for the funds in 2014 for that plan. And the new plan that you submitted in 2017, these other people have said that plan is okay, but first the court has to make a legal ruling as to how you're affected by this contract. That's not exactly the same as we give unlimited approval.
Well, I think it is, Your Honor. What they've said is, as far as we see it, we, the county commission, which by the legislative, the statute is the county, is what they've said is, we've approved it. Now you got to go back and get the court to say it's okay. So, but how can in that instance, and EPE did this by way of a supplement to the existing plan. So how else without standing to go and take that next step just so that the funds can start to flow if you don't have standing to go get the court to approve it? I think that is the seminal issue here, is that you've been granted something. How do you get the court to approve something if you can't go to the court? If you tell me you have to go get Chancellor Cowell to do X, but you say we're going to put a guard at the door and he's going to tackle you every time you come to the courthouse, you have no chance. You have no chance to ever. You've been deprived of a right. But
do those other approvals then require the chancellor to rule your way on the merits of the contract interpretation? No, they can't direct him to come to a certain outcome, can they?
No, they don't direct him to come to a outcome. They say it's you go and get the outcome from him. If he agrees that you can do it, you're blessed to move forward. If he says you can't do it, then you cannot move forward. So EPE's whole existence lies in its ability to get this contract interpreted vis-a-vis the provision that I just read. That's what we're focusing on. We're not focusing on anything related to the Grizzlies or the city and the Memphis and who pays a seat tax. It's focused solely on the provision that it says in private developers with tax incentive programs, like a Graceland TIF, like a TDZ, and like a surcharge. So when you take that and you focus on that provision, the resolution combined with the existing TDZ and surcharge, there's how you arrive at your standing in order to get this interpretation and why EPE is being deprived of a right. EPE, it's not up in the air as to whether or not EPE will have a TIF, a TDZ, or a surcharge. They have that. The question solely is, what all can you do under that? And the only way to get that is to have the court tell us, what does this provision mean vis-a-vis EPE? And that's all that's being sought here. No benefits, no money from the city, the county, the Grizzlies, or to stop anything flowing to any of those entities. That's a very unique, and I coined that as a carve out. That's a very unique carve out. If you had, in fact, it's so unique that EPE really is the only entity right now positioned to even make this challenge. That's why EPE is akin to the individual homeowners in Calfee, because it's their tax program that's in place. All the planets have lined up, so to speak, Your Honor. And so that's why I think that that you have the standing to get the interpretation. That's what you're asking. That's what EP is seeking, the opportunity to get the interpretation.
Well,
And-
actually, the city could do it. The county could do it, right?
Well, Your Honor, they could do it. They won't. They've made very clear that they don't want this interpretation, so they're not going to get it. So they're in further.
They don't want to pay the freight. They don't want to pay all of you lawyers to get the interpretation. They want to sick you on it.
Well, Your Honor, with all due respect, it would have been a lot cheaper if they would have just said, we want the interpretation. Everybody could have signed up, went to Chancellor Cowell and got interpretation in a day, and it would have been a lot cheaper than today is probably, Your Honor. So they just don't want it. So EPE is you know, as the phrase go, they're very hamstrung here, as hamstrung as a citizen can be by this agreement. The outcome here doesn't change anything relating to the Grizzlies, Memphis basketball, or the city or the county. It relates solely to EPE's tax incentive program. And then finally, Your Honor, if I could address the res judicata point as I close. I think Mr. Wade did a very good job of explaining why the Court of Appeals was wrong. Because what Mr. Wade helped establish, and I think, is that what Chancellor Cowell, what happened here is, according to the Court of Appeals, Chancellor Cowell said, EPE, I can't hear you. There will be future litigation, but first you have to go back and get administrative remedies, exhaust them, and then you can come back and have your day in court. That's what happened here. So what now Mr. Wade has said, we want to deprive EPE of its day in court. Let's just deprive them all together. And thank you, Court of Appeals, for helping us do that. Because had Chancellor Cowell said anything other than administrative remedies, which EPE's counsel very well understood that is exhausting administrative remedies. You don't have to go back and appeal something of administrative remedies, because you can go and get them and exhaust them. But so in this case, that not only did they exhaust them to their own favor. They EPE, and I was the person that showed up for EPE. So EPE didn't just show back up and say, Your Honor, we exhausted him. We didn't only do that, because when you look at the record, Chancellor Cowell said, I can make Edge vote. I can't make them vote favorably for you. If you go back, they're going to vote. I can instruct them to vote. He didn't even have to instruct them. They voted, and it was better. We got a favorable ruling, a favorable vote. So
well, Mr. Wilson, why didn't you go back on a Rule 59 motion and let Chancellor Cowell know about that? That's what Mr. Wade argues, that you should have filed Rule 59 and essentially updated the court on the progress.
Your Honor, because Rule 59 doesn't run in perpetuity. It had been months, it had been several weeks and many, even months since Chancellor Cowell had issued his ruling. And the fact that the city of Memphis had filed a Rule 59, that did not toll it for every other party, because if that operates that way, if it's a multi-party case, every party could just say, okay, it's been 30 days, he hadn't ruled. You file yours next. You file one. And you could just Rule 59, this just keep filing them for years to come. So we didn't.
Well, so
didn't
we,
allow.
Mr.
I'm sorry.
Wilson, this is Justice Kirby. We certainly do, though, look often at whether a second lawsuit between parties alleges a claim that could have been raised in the first lawsuit. That is an issue that is routinely litigated, and whether it's res judicata, whether it's precluded. So I'm not hearing you say that you couldn't have brought it to the trial court's attention at that time.
I will say it now. We could not have, because this is not undiscovered evidence. This is not, facts that existed and EPE failed to, bring that to the court's attention. The best example with this is to describe this as two different car wrecks involving some of the same parties. The fact that we wrecked our blue and red car on Friday and we're there, we have another crash on Monday even though we're still in the blue and red car, it's not the same car wreck. So we went back and exhausted administrative remedies and did all the things that the court specifically instructed us to do. That was a new case that needed to be filed separate. You couldn't go back months later under Rule 59, Your Honor.
All right. Thank you.
Thank you, Your Honor.
Thank you, counsel, for participating here today. We thank those of you that have joined us on YouTube as well. This concludes our docket for today. Our oral arguments. We will have one case tomorrow morning. With that, Mr. Clerk, if you will recess court for the day, please.
This honorable court is now adjourned.